Hey, everybody. This is your daily dose of all things royal. Welcome back, my gorgeous, good looking friends. Of course, this morning I wake up with a flood of Prince Harry and Meghan Markle news, with one, Meghan Markle doing another pap walk again, and then Prince Harry's home office case is being decided in the next couple days. And what's happening between now and Friday is trying to overturn the ruling that saw Prince Harry's security status downgraded after he stopped being a working royal. Here's my honest assessment of what I'm watching here. The reporting coming from the mainstream media, disregard that. We're not being told the real story of this court case. And there's a reason why this court case is being conducted privately than being shared with the public. And that's because, in my opinion, after I share with you all my evidence, is that Harry is not being honest, the government's not being honest, and King Charles is not being honest. So we're going to get into this now. You might ask yourself, and I did too, why are they even considering this court case when they originally had turned down Harry's offer to pay for this police service? Well, the simple answer is it has a lot to do with his immigration status, and that's what I believe. Now, Harry and Meghan want everyone to believe that they fled Canada in March because the borders were closed and because of COVID, but in previous videos, I have shown you evidence that they were here long before that. Anyhow, we'll get back to that in a second, but I just want you to keep that in your head for a moment. So, in this filing dated July 22nd, 2022, Harry gets the approval for this to be heard. And in this judgment, let me give you some information from it so you can understand a little bit better as to how we arrived to today. You see, Harry was told in the Sandringham summit that he was not going to be able to keep his security. Finally, a letter went out to Harry on February 28, 2020, telling him that his security was going to be pulled by the end of March. See, here was the problem. Meghan and Harry refused to share any of their plans with the family because they were telling them a story of being in Canada, but in reality, they were in the United States. And we know this because Meghan filed a lawsuit against Splash News for invasion of privacy against taking photos of Archie, which apparently the media was reporting that this happened in July, but it didn't. It happened in March. Anyhow, we know that there's evidence that they were in the United States way before they leaked it to the public, as we know that Meghan leaks everything. Let's not forget that they were going off to Stanford and they were in California. So-called Archie having trips and seeing his grandmother. Now, we're in the height of COVID and they're traveling all over the place back and forth to Canada. I don't think so. Now, if that doesn't convince you, just hang with me because I'm going to show you new evidence that I found today, which would make total sense as to what is going on right now. Now, getting back to Harry's case with the Home Secretary, you can understand why at the time they felt that they weren't under any kind of threat and felt that they didn't need this extra special protective services because Harry and Meghan did not give them any kind of insight as to what their move forward plan was to assess that, as it says here. And that would make sense as to why they didn't disclose it because most likely they were lying because they were in the United States already. I call bullshit on the media spin that the Harkle propaganda machine is pushing out of Harry doesn't feel safe going back to the UK with his family because he doesn't have the level of security that he has in the United States because his protection officers here can carry guns and in the UK they can't. And this special protective services has a team where the officers can carry a gun. This is all bullshit because I don't think anybody really understands the level of security that he's requesting back. So he's asking for his old security to come back. Literally all the bells and whistles that come with his special status. And they're not talking about what comes with it. And I find it interesting that Harry was adamant that a lot of this stuff was redacted in his court case, detailing the types of protection that he would be getting under his legacy protection when he was working as a royal. As you can see here, they redacted a lot of things that pertain to the type of protective security operations that Harry used to have. And I'm not sure if this was done on accident or if it was purposeful, but in the judgment that came down recently to when the justice said, no, Harry, you can't pay for the police out of your pocket, giving reasons. If people actually read through that document, you would find out the kind of security services that Harry is looking for. And this is what I want to expose to everybody so you can understand why it's so important for him to get this back. It's not about, oh, when I go back to the UK, I want to feel safe and protected. No, you need to understand what's included with his legacy security that he used to have. It says right here, up to that point, protective security had been provided for them by specially trained officers from the Royalty and Specialist Protection Command, RASP, of the Metropolitan Police Service, MPS. There it is, folks. That's what he is asking for. It's very peculiar that when you go to the Metropolitan Police website and you look up the RASP protection services to learn all about it, they no longer have it listed on their website. Thank God the internet is forever. I was able to find an archive page in which it details all the bells and whistles that Harry would be receiving if he got back his original security. Let's take a look. So, the Royalty and Specialist Protection Division, or RAS, is responsible for protection of the royal family and for high profile public figures such as members of government and visiting royalty and dignitaries. They provide protection for anyone considered to be at risk, where intelligence, that's a key word, suggests it is necessary, and those who have been identified as needing protection by the Executive Committee for the Protection of Royalty and Public Figures. To provide round the clock residential security at royal residences, protecting members of the royal family and visitors. Some of their responsibilities included personal protection for the royal family, both nationally and internationally. Meaning, yes, they would be responsible for protecting these two idiots in Montecito. Personal protection for the prime minister, certain government ministers, certain ambassadors, and high profile persons, and for visiting royalty dignitaries. Protection of others where is in national interest to do so, where intelligence suggests it is necessary, and for persons who have been identified by the Executive Committee for the Protection of Royalty and Public Figures. So, no doubt, little Betty and Archie are going to be blanketed under that for life. Probably, maybe Doria will get it, because if Meghan has her way, because she is a woman of color, she's going to use that to get that security over there. Let's see what else they have. Protecting royal residences in London, Windsor, and Scotland. Well, he doesn't have a place to live anymore, so that might not be a problem. We've got protecting members of the public who visit royal residences. Oh, so if Meghan wants to bring over any kind of narcotics dealer, I'm sure they would be protected. Then you have, oh, this one's important for Meghan, special escort group mobile protection for protected persons. Ah, you got that, folks. Mobile protection for protected persons. That's that IPP. That's that motorcade that Meghan wants to look important. Then we have, and this I find the most dangerous perk to be given to Meghan and Harry, is the Fixated Threat Assessment Center, which is the access to this intelligence in which they are responsible for assessment and intervention in relation to people fixated on protected persons and sites. So there you have it, folks. This is all that Harry is asking for to come back to him, and for the people of the UK to pay it, as well as any country that they visit. You're going to have to shell out the dollars to take care of these two dangerous fools. I think we really need to make a stink about this. And I know that now, and just seeing what has been going on, Harry is desperate to get this back. And the reason why is because it's threatening his immigration status here at the moment. And how I know this is discovering some information from the court case that is happening here with our Homeland Security. Let me show you what I found. So, yesterday there was an update to the Heritage Foundation's lawsuit against the Department of Homeland Security regarding the information about Harry's visa. Now, as I was reading this, I was having a difficult time in understanding the reply from the Heritage Foundation in countering some of DHS's, want to say, excuses. And then I realized something. I realized that there were two declarations that I did not see. And that's because for each of these documents, you have to pay for them. And for whatever reason, I didn't think that the declarations meant anything. Boy, was I wrong. So, what I'm going to do right now is I'm going to go through one of these declarations. In the next video that I do, I will provide an update on this recent filing, but I think it's important that we take a step back and we look at this one declaration. I think it's going to blow your mind. So think of these declarations similar to like a subject matter expert. So they're making a declaration on behalf of the plaintiff who requested their expertise and assessing the situation based on their personal knowledge and expertise. So this guy who they brought in, his name is Andrew Arthur, and he is recognized as an expert in the area of immigration, generally, and immigration policy specifically. Okay? To that end, he says that he testified before Congress on 11 different occasions on immigration issues and have been quoted on immigration issues by national media such as the New York Times, Wall Street Journal, Washington Post, Los Angeles Times, and so forth. He goes ahead and he puts his background in there, and from what I can tell, it looks extremely impressive. He says he served as a resident fellow in law and policy at the Center for Immigration Studies, an independent, nonpartisan, nonprofit research organization dedicated to providing immigration policymakers, the academic community, news media, and concerned citizens with reliable information. Prior to that, he served as staff director for the U.S. House Committee on Oversight and Government Reform, National Security Subcommittee. He also served as an immigration judge from 2006 2015, and he served as counsel for the U.S. House of Representatives Judiciary Committee. And on top of that, he has a law degree from George Washington University and has graduated out of the University of Virginia. So this guy seems pretty solid. So here is his assessment. So, for the purposes of the analysis, he assumes that the Duke of Sussex is legally in this country. That is to say, he has been admitted and granted some lawful immigration status by the relevant authorities. Bullet 10 says, the Duke of Sussex is one of the highest profile individuals in the world from politics to pop culture. I believe the Duke of Sussex to be unique in terms of disclosing virtually every aspect of his private life for commercial gain. So listen to how he lays this out. As an initial matter, I do not understand that any of the defendant Department of Homeland Security's declarants have disputed that the Duke of Sussex would have been required to answer in writing the question of whether he used mind-altering substances prior to lawfully entering the United States. That is law. One must answer that question when applying for admission into the United States. If the Duke of Sussex were not asked about mind-altering substances use prior to admission to this country, it would be an extreme abuse and abdication of defendant's legal duties. He also makes the point that this is a basic fact under the Immigration and Nationality Act, and it is binary. It's either the Duke of Sussex told the truth or he didn't. Simple as that. Two possible scenarios. The first scenario is if the Duke of Sussex told the truth. So, assuming the Duke of Sussex told the truth, he would be inadmissible under this section that they list here, which provides, except as provided in clause, any alien convicted of or who admits having committed or who admits committing acts which constitute the essential elements of a violation, any law or regulation of state, the United States, or a foreign country relating to a controlled substance, as defined in that section, is inadmissible, meaning he shouldn't have been allowed in. But the gingerbread is here. So the only way the Duke of Sussex could overcome that bar and lawfully be in the country in such a scenario is if he received a waiver under the section listed there. So he makes it simple by saying, put differently, we know the Duke of Sussex sought and was granted a waiver under this section if, and that's a big if, he told the truth. It continues on and says, in light of the foregoing, I do not understand the basis for the repeated statements by the defendant, meaning DHS, that simply identifying whether records regarding any request for a waiver pursuant to section listed there exists would confirm that the Duke of Sussex may have required a waiver before any travel to the United States, or that to reveal whether such a waiver has been sought would reveal privacy protected information. Again, the option is binary. Either the Duke of Sussex applied for and received such a waiver to inadmissibility, or he lied and in so doing both committed a felony under fraud and misuse of visas, permits, and other documents, and rendered himself immediately deportable under this section, as explained below. So now let's look at scenario 2, which is, let's say the Duke of Sussex lied. In general, any alien who, by fraud or willfully misrepresenting a material fact, seeks to procure or has sought to procure or has procured a visa, other documentation, or admission into the United States or other benefit provided under this chapter is inadmissible, meaning barred from this country. That lie or Harry's truth would have been material for purposes of Section 212, yada yada, INA, because the Duke of Sussex would have been inadmissible based on the true facts and or the misrepresentation cut off a line of inquiry that is relevant to his eligibility for admission, and that might have resulted in proper determination that he be denied admission. Now, here's where it starts to get juicy. Had the Duke of Sussex been admitted to the United States by lying about his drug use, he would be deportable under Section 237, which states inadmissible aliens. Any alien who at the time of entry or adjustment of status was within one or more of the classes of aliens inadmissible by the law existing at such time is deportable. Again, not only would the Duke of Sussex have been inadmissible under Section 212 INA law because of his mind altering substance use, but he would have been inadmissible under Section 212 of the INA law for his misrepresentation about his mind altering substance use. Therefore, he would be deportable under this Section 237 INA law because he was inadmissible at the time of his entry. So if he lied, and we discover this now, he needs to be deported as of yesterday. So this expert's opinion says that DHS treatment of the Duke of Sussex immigration status raises substantial questions as to whether, at best, DHS engaged in improper or negligent conduct by giving preferential treatment to Prince Harry. If the Duke of Sussex truthfully disclosed his now publicly admitted mind altering substance use at the time of his entry, it is his opinion that DHS may well have acted improperly in granting a waiver under Section 212 of this law. If the Duke of Sussex lied at the time of entry, it is his opinion that DHS almost certainly acted improperly in failing to take immediate action against him in the aftermath of Spare and its attendant media rollout. I have to say, this is a pretty good argument. And he continues on with this thought process by saying, under either alternative, it is his opinion that the current record warrants a belief by a reasonable person, like you or I, that the alleged government impropriety might have occurred. And I would have to agree. So now going back to scenario 1, let's say he did tell the truth, then most likely DHS granted him a waiver. But what this expert is saying is that any waiver would likely require a lengthy processing time and a number of affirmative steps to examine his mind altering substance use. Okay. Stay with me on this because this very much ties into what I was saying earlier about when Meghan and Harry really came to the United States. So Andrew goes on to say that he reviewed all the information that was in the court documents. And given the fact he knows how difficult and lengthy this process is for a waiver, he lays out the hurdles that Harry would have had in front of him for using these mind altering substances, in which he lays out first. The conduct in question is not incidental, fleeting, or occasional. It is long-standing and frequent. For long periods of time, it was part of the Duke of Sussex almost daily routine. True. Second, none of the use was pursuant to lawful medical guidance, and the use attributed to therapeutic purposes was unlawful. Moreover, much of the use was not temporary and incidental to an emotional trauma or in response to a medical event. It was deliberate and for recreational purposes. Man, facts will be your best friend in a time like this. Third, although the Duke of Sussex's mind altering use began as a minor, his mind altering use continued and was at its most chronic well into the Duke of Sussex's adult life. The mind altering substance use was not youthful indiscretion, it was a deliberate and ongoing adult choice. So now this is going to get spicy. Fourth, the conduct is not confined to the ganja use in small doses, but included the use of a number of other scheduled mind altering substances. And he has admitted to heavy mind altering substance use impeding basic functioning. That's true. Fifth, the conduct was illegal in the country in which it occurred. This was not the case of legal consumption in a foreign country. And six, the conduct reflects contempt for law and order. Much of the adult chronic mind altering substance usage occurred in England, while the Duke of Sussex was a senior working royal and held government office, which he still holds. I would like to remind everyone, especially my listeners who keep pushing back and saying, oh no, Harry doesn't have anything to do with the family, and the website is just taking forever to update. This is an international immigration lawyer. Guy knows his stuff. So he is specifically stating that Harry still holds an office position. So for those that want to come at me and say Harry has no place in the monarchy, well, all I can say is I can lead a horse to water, but I can't make it drink. So if this is not evidence enough to say that yes, Harry is still tied in the institution, then I don't know what else is. And this does affect Harry's court case in the UK, and it also affects this case here in the United States. You will see in a second. Let me just finish this up. Now, from what I gather here, under this Regency Act, that the chronic commission of such offense while in office on, for example, Windsor Castle grounds and while protected by a government security detail would be seen as showing and breeding contempt for law. Didn't we hear about Meghan and Harry doing these mind altering substances when they were back in the UK? Allegedly. So here is the nugget of information that solidifies for me that Harry and Meghan were in the United States before the so called published date that Meghan leaked, in which, taking on face value, and I can tell that this guy knows nothing about the shenanigans of Meghan and Harry, if you take for face value what they said is true, the expert goes on to say, turn to the apparent ease of the Duke of Sussex's entry. The Duke of Sussex's actual entry to the United States to take up residence is documented via selfie video of his family flying in via private jet on March 14, 2020 at around 6 a.m. See Harry and Meghan Netflix episode 6. Poor thing, sounds like he was subjected to watching that. Anyhow, he continues on by saying the Duke of Sussex writes in spare, obviously prior to March 14, 2023. In March 2020, the World Health Organization declared a global pandemic, and Canada began to discuss the possibility of closing its borders. But Meg had zero doubts. They're definitely going to close those borders, so we need to figure out somewhere else to go and get there. spare at page 388. In other words, the Duke of Sussex was able to enter the country in a matter of weeks. The point he's trying to make here is essentially this, like this last minute decision to go to California before the borders close, in conjunction with the lengthy process to get one of these waivers, in addition to the Duke of Sussex having no issue getting into the country or returning from the United Kingdom, just shows that something's off. So his opinion goes on, and he explains that the reason why we go through these processes is to protect our society. And we weigh based off of various factors on whether or not we let people in. And in this case, it's trying to understand whether or not we followed the rules. Did Harry and Meghan come in here earlier? I think that's an angle that nobody has explored yet, because for the most part, the people that don't know anything about Harry and Meghan take what they say at face value. We know that they're liars, and we can prove that this is most likely what happened. But here is where I interject and say that Charles is very much a part of this. As long as Harry's on that website and is Counselor of State, he is telling the world that Harry is part of the institution. And we may not know what coverage he has from a security aspect, but you can bet that in the United States, we are protecting this motherfucker. Here's what I think happened. There's a reason why in that court document from Ravak said that they didn't know about Harry and Meghan's framework moving forward. There's a reason why Harry and Meghan kept that secret. I believe that Harry applied for a visa way in advance when he had this special status and protection and got all his proper documentation together. That's how he got in and out of Canada and then into the United States and then to the UK and then back to the United States with no problem. It's because all those affairs had been settled. Keep in mind, Ashley Hale, Samantha's daughter, is an immigration lawyer. So who do you think helped him? Now, this last point that I want to raise from this declaration is the point that the only exception to the rule is entry under a non-immigrant category A visa. Yes, folks, which applies solely to diplomatic entry, which I believe is what happened. So let me leave you with this, and we're going to pick this back up in talking about the Heritage Foundation's recent filing, as this part is from the Heritage Foundation recent filing. They write, for the first time in its reply, defendant, meaning DHS, seriously contends that the Duke of Sussex, no longer a working royal, is nonetheless in the United States on a diplomatic visa, which would require that he be an ambassador, public minister, or career diplomatic or consular officer who has been accredited by a foreign government, recognized de jure by the United States, and who is accepted by the President or by the Secretary of State and the members of the alien's immediate family. Come on, guys, you don't think Charles has a hand or at least is playing a part in this? Anyhow, it continues. To start, that argument proves too much in that if the Duke of Sussex actually is here on a diplomatic visa, that diplomatic accreditation would be in the defendant's files and is responsive to plaintiffs' FOIA requests. One cannot seriously assert a privacy interest in the fact that they are an accredited diplomat. The defendant would be required to disclose the materials related to the diplomatic note. Now, here's where the records scratch for me, and I'm not sure if this is a mistake or, yeah, we just caught the UK government hiding information from the public, in which it said, moreover, it is simply bizarre without more to suggest that the Duke of Sussex is diplomatically accredited to the United States, given, one, the relative spontaneity of his decision to take up residence in the United States, and two, the fact that the British government removed official security from the Duke of Sussex in February of 2022 because he was no longer a working royal and diplomatic status was never mentioned in HRH's subsequent action for judicial review. I don't know, guys. This seems like too big of an error to make in a court document like this. And when you think about it, Harry filed his lawsuit against the government back in January of 2022. Could he have known that whatever special remaining services he was getting was coming to an end in February? I don't know, folks. When you think about this and you look at all that's happened, how many times have we like questioned saying, why is the UK government doing this and wasting time and money to entertain this fool? I personally believe that this court case is all for show. It's to show the public that, yes, the judicial system is working and we are treating Harry just like everyone else. I think the plan all along is to give back Harry his IPP status. That way, it can shut down any of this stuff that's going on here. Because if he is considered a diplomat with IPP, then he's protected and they don't have to disclose any information about him. What concerns me is the monarchy's involvement with this. And as long as Harry's on that website, and as long as Harry's listed as a counselor of state, and our government here, as well as our legal documents, are reflecting that he is seen in that manner, that's a huge problem. That means the monarchy is lying to the public. I don't think it's so much the website that we should be screaming about. I think it's about this counselor of state. And as long as he's still listed as one of them, he is still a part of the institution. Sugarcoat it any which way you want. Harry is still a part of the firm. Perhaps this was the plan all along. I do believe that there is a scandal brewing here, and the US and the UK are trying to keep this under wraps. That's just my opinion. We'll just have to see how this unfolds. But what do you guys think? I mean, me presenting some of this new information, it does give me a new perspective. Was this planned ahead of time? I mean, I already shared my thoughts, but do you think that Harry and Meghan were here before the announced March 2020 that they came over here? Do you think that King Charles was aware of Harry's plans to come to America? I do think there's some truth of Harry having discussions about leaving the firm. I just don't think that we were given the truth around what exactly was discussed. Definitely leave your thoughts. As always, I will be back with more content, but until then, please be safe and I'll talk to you later. Bye.
It was such a fraud.